Evening. So today, as I had earlier promised you, is that we will be doing an analysis of various cause outlines, and one of the cause outlines that we will be starting with is the criminal litigation cause outline. So, and in this cause outline, we'll analyze step by step and procedural aspects emanating from each part. Then we'll be breaking the sessions through oral parts to avoid a monotony. So I've projected before you the criminal litigation cause outline, so that we dig deeper in what it entails. So if you check on the first week, you are required to master generally the criminal litigation contents and overview of the criminal law principles. Then you are to check on the jurisdiction and structure of courts. Then arrest without warrant and arrest with warrant. So if you are keen, we have been told to use a drafting component where we have arrest without warrant and arrest with warrant. So these are the issues that we can't skip because anything is possible at this time. Let me convert what I have to PDF. It is criminal litigation. So I'm converting the criminal litigation cause outline to PDF, to Word from PDF. So PDF to Word converter. And one of the principles that I've realized is that if you are in a position to break down the various complex litigation principles into procedural technicalities, then you'll be on the safer side. So in a few, I'll sort of So thank you, Ringera, for joining. I've said that after analyzing one of the cause outlines, we will be breaking down to orals, and these orals are very, very practical in nature, inclusive of the current affairs. So I'm converting my criminal litigation unit cause outline to Word. Good, it is done. And there's the project work. And cause outline, PDF to Word. So this is it. Download. Okay. So I've begun from week 4 and 5, and of particular interest is arrest without warrant and arrest with warrants. And there is a reason why the examiner expects us to have the drafting element or a drafting component attached to it. So we'll also see the necessary applications to draft. So the key takeaways is that whenever you are dealing with arrest without warrant, it is imperative to note that the Kenyan police can lawfully arrest anybody without a warrant, but only where a statute will be authorizing the same, typically on reasonable suspicion of a cognizable offense. And the arrest must comply with Article 49 of the Constitution, otherwise the same will be unlawful and can attract constitutional damages. So if you read section 29 of the Criminal Procedure Code, it states that arrest without warrant can occur where a police officer may arrest anyone without a warrant if the person is suspected on reasonable grounds of having committed a cognizable offense. Okay? Then, if you read Section 58 of the National Police Service Act, it still provides that the National Police Service also has express arrest without warrant power in specific circumstances. So maybe during orals, you'll be asked to give various examples of the circumstances that can lead to a police officer arresting you without warrants. And if you read Section 58 of the National Police Service Act, the title is Power to Arrest Without a Warrant. So subject to Article 49 of the Constitution of Kenya, a police officer may, without a warrant, arrest a person, A, who is accused by another person of committing an aggravated assault in any case in which the police officer believes upon reasonable ground that such assault has been committed. B, who obstructs a police officer while in the execution of duty or who has escaped or attempts to escape from lawful custody. The other situation is where whom the police officer suspects on reasonable grounds of having committed a cognizable offense. And D, who commits a breach of the peace in the presence of the police officer. And E, in whose possession is found anything which may reasonably be suspected to be stolen property or who may reasonably be suspected of having committed an offense with reference to that thing. Then F, whom the police officer suspects upon reasonable grounds of being a deserter from the armed forces or other disciplined service. And G, whom the police officer suspects upon reasonable grounds of having committed or being about to commit a felony. And H, being the last one, whom the police officer has reasonable cause to believe a warrant of arrest has been issued. So in summary, these are the situations that you will be required to know whenever you're talking about arrest without warrant. Section 58 of the National Police Service Act. Okay? Aggravated assault, obstructing an officer from conducting their duty, reasonable grounds of a cognizable offense, breach of peace in presence of the police officer, suspected to have stolen property, a deserter from the armed forces or any other disciplined service, or reasonable grounds you have or you are about to commit a felony. Or lastly, he believes that there is a warrant of arrest that has been issued upon you. So those are the key takeaways that I wanted us to make sure we have mastered. So further to our analysis of the same is that if a private person arrests without a warrant, they must hand over to police or take you to the nearest police station without unnecessary delay, and the suspect must be released if there is no sufficient reason to believe that an offense has been committed. This is pursuant to Section 35 of the Criminal Procedure Code. Okay, so from the Criminal Procedure Code, we can extract two provisions. Section 29 on cognizable offenses, where we have reasonable grounds, and Section 35 where we have private persons being involved in this procedure. So basically that is what the examiner will be requiring. So now let us look at arrest with a warrant. And if you are keen, this is the point where the session even went to be beyond theory, and the lecturer even projected an application where a police officer is applying for arrest warrants over an accused or a suspect, over a suspected individual. Okay, so when we will be discussing on arrest with warrants, I will also attach the drafting part involved, because I'm approaching criminal litigation in the aspect that it is the most failed unit this year with a percentage of 8.1. Okay. So arrest with a warrant will be lawful where a competent court has issued a valid warrant and the executing officer complies with the Criminal Procedure Code requirements, okay, where he should identify, notify, show the warrant if demanded, and present the arrestee to, sorry, I've lost the notes that I'm relying on. Open again. Okay, sure. I lost my notes in a few my laptop. Okay, yes. So I was saying that an arrest, a warrant of arrest is provided under section 102 of the Criminal Procedure Code, and that you should take note that a warrant of arrest must be signed by the issuing judicial officer. It should bear the court seal and should state the offense, name and describe the person, and command the addressee to apprehend and bring the person before the issuing court or other court with jurisdiction. It remains in force until executed or cancelled. That is what section 102 of the Criminal Procedure Code stipulates. And then a warrant may be directed to one or more of police officers, or generally to all police officers in the area. Exceptionally, it may be directed to another person if immediate execution is necessary and no police officer is available. This is pursuant to section 104 of the Criminal Procedure Code. Okay, and then section 106 of the Criminal Procedure Code continues to tell us that if directed to a police officer, it may be executed by another police officer whose name is endorsed on it. Okay. If you read section 111 of the Criminal Procedure Code, where a warrant directed to a police officer is to be executed outside the issuing court's jurisdiction, it should be taken for endorsement by a magistrate within the area of execution, with a limited no endorsement if delay will defeat execution exception. This is the direct reading of section 111 of the Criminal Procedure Code. Okay, so this applies to where a warrant is being issued outside the jurisdiction of a certain police station or court. You will be required to take it for endorsement by a magistrate within the area of execution, but there is an exception if the endorsement will defeat execution. That exception has been allowed by section 111 of the Criminal Procedure Code. Then if you read section 110 of the Criminal Procedure Code, it tells us that the issuing court may forward the warrant to a magistrate within the area for endorsement and execution. Okay, so the issuing court may in itself forward the warrant to a magistrate within the area for endorsement and execution. That is the reading of section 110. Okay. So what will you draft whenever you are encountered with a situation where you have been told that you are acting on behalf of a certain police officer who wants to apply for these warrants? So you will approach court through a chamber summons being brought under section 102 of the Criminal Procedure Code and the inherent jurisdiction of the court, where you say that take notice that the accused or applicant shall apply for orders that 1. The warrant of arrest issued on this date be recalled or lifted, and or execution stayed pending the applicant's appearance on a fixed date by the court, and the applicant be permitted to present himself or herself before this court on this date for mention and cost in the cause. And the grounds that you'll be seeking will be that the applicant has not absconded or had reasonable cause for non-attendance, the warrant is irregular on its face for want of compliance, and that the warrant was executed and attempted outside jurisdiction without endorsement. So this will be an application to lift or recall warrants of arrest, but not to apply for the same. Now let me do an application for application of warrants. Warrants of arrest. And the grounds that you must identify for you to be granted these warrants of arrest. So basically, you are supposed to file an application in the trial court or high court on revision. Okay. I want to do an application. Okay. So the application now that you will be seeking as the investigating officer for application for issuance of warrants of arrest. Remember, the title of the case will have a mark, Republic of Kenya, in which magistrate court. This is where the examiner will look at the jurisdiction that you are making this application to. It is a miscellaneous criminal application, or if the file already exists, you will list the criminal case number. In the matter of an application for issuance of a warrant of arrest, and in the matter of you state the offenses that have been committed by this suspect. In the expertise, you will be addressing the officer commanding the station, being the OCS, where the investigating officer is the applicant versus the respondent, who is the suspect. You give his details. Then the application will be brought under an expertise chamber summons, and in particular, the examiner will be interested in the enabling provisions pursuant to section 90, 101, and 102 of the Criminal Procedure Code. Let the applicant move this honorable court for orders that a warrant of arrest do issue against this person to compel attendance before this court to answer on the offenses of, you list the offenses. The officer to whom the warrant is directed do arrest and produce the suspect. Okay. So you also do a supporting affidavit to that application. So basically that is what the examiner will be looking at. And in the supporting affidavit, being the investigating officer, will be saying that you are the investigating officer in the matter, that there was a complaint that was recorded under this OB number, and that the investigation to date disclosed the offenses and released the ingredients of the offenses or the offense alleged. The suspect is identified as this. You give a brief description of the suspect together with his phone, address, etc. That there is a reasonable apprehension that unless arrested, the suspect will either evade the attendance, interfere with witnesses, or commit further offenses. That it is in the interest of justice that the court issues a warrant of arrest to compel attendance pursuant to CPC section 90, 101, and 102. So that was the application that we began our classes by drafting. So I believe up to that point I've discussed situations that require an arrest without a warrant, and where arrest warrant is to issue. Do you know the drafting application you will make? Because we saw earlier, if I want now to do an application to recall a warrant of arrest, you move the court under section 102, 107 and 108 of the Criminal Procedure Code, because now you'll be acting on behalf of the suspect. Being an advocate, you'll move court through a notice of motion, and you'll be stating that the applicant be allowed to present himself or herself before this honorable court, and that the bond or cash bail be reinstated, and that you are willing to cooperate. So you have to put yourself in the shoes of two probabilities. Hello? Hello? Yes? Okay? Yes. Okay? Yes. Okay. Sawa, sawa. Sawa, thanks. I just feel I undertake, yes. Sawa, aye. So I was saying that you should put yourself in the shoes that you can draft an application requesting for warrants of arrest, and at the same time you can do an application to revoke or to set aside those warrants of arrest as an advocate of the accused person. So the examiner will test you on either of those procedures. We have said that if you are the IO, you move the court through an ex parte chamber summons, section 90, 101 and 102. But if you are the advocate for the suspect, you move the court accordingly through a notice of motion under section 102, 107 and 108 of the Criminal Procedure Code. So up to that point, I believe we have delved deeper to that part. Then if you read week 6 and 7, we were required to know what identification parades entail, what are the procedures, what are the rules that govern identification parades, what are the mistakes that various police officers usually conduct in such activities. And basically this is a potential question even during oral. You'll be told to give various rules that govern identification parade. Let me search for the enabling. No, it is police, national police standing orders. Standing orders. National Police Service standing orders. So I've opened the cell. Let me read the exact part. Let me search. Okay. So it is coming up to chapter 46 of the standing orders. Let me jump to 46 so that we read in verbatim. Okay, I'm almost. Chapter 46. Is it chapter 6 already? Okay. Yes? Hey, wakili niko live. Is it champagne? That's right. Lakini shule la kesho. Magari nataka kuongana na tena. Sunday sisi mbali. Ni mbali. Thank you for your indulgence. Section for chapter 46. I can look at the same. They are not adding up to section 46. Let me read a certain decision here to see whether it is addressing the same. Okay. So we're still on identification parades, and I'm trying to figure out the exact rules that form part of identification parades so that we read step by step and in a procedural manner. Okay, So hold on. So there was a change from the older National Police Service Standing Orders of 2017 to an updated one. That's why you'll note that there are some provisions missing. So let us look at the latest available version. I found the latest available version. Let us go to the relevant part on identification parades. And this will be chapter 46. Let me confirm. Research. Identification parades. Chapter 42, where the title is Chapter 42, Guide to Criminal Investigations. Then we narrow down to Identification Parade, which is section 7. So the police shall organize an identification parade to ensure fair and correct identification when the whereabouts of the accused or suspected person is known to the police, but there is some doubt as to whether he or she is the person so accused. The police shall not take a witness direct to an accused or suspected person for the purpose of identification, except when they are sure that the accused or suspect is well known to him or her. Okay. So these are the rules that we will analyze. The police shall not compel any suspect or accused person to appear in an identification parade. And where a suspect refuses to appear in identification parade, he or she is subsequently charged. Evidence of his or her refusal to take part in an identification parade shall be adduced in his or her trial. Okay. So it should have the consent of the suspected person, where the accused or suspect for the purpose of identification, we are sure that it is well known to him or her. Where there is recognition, that will be an exception, because let me read to you a certain element before we jump into the analysis, so that you can understand the difference between recognition and where the ID parade will be necessary. And also we touch on block identification briefly. This is I'll never get to the bottom of it. So I'll have to finish her first so that we can look at various decisions. The officer conducting the parade shall, at the time of holding the identification parade, complete all relevant sections of report of an ID visits person to Form 156P 156, which shall be used by the conducting officer to refresh his or her memory in any subsequent court proceedings as authorized by Section 167(1) of the Evidence Act. Where a witness is asked to identify an accused or suspected person, the following procedure shall be followed. Okay. 1. The accused or suspected person shall always be informed of the reasons for the parade, and that he or she may have a counselor or a friend present when the parade takes place. B. The police officer in charge of the case, although he or she may be present, shall not conduct the parade. C. The witness or witnesses shall not see the accused before the parade, and the accused or suspected person shall be placed among at least 8 persons as far as possible of similar age, height, general appearance, and class of life as him or her. E. Where the accused or suspected person is suffering from any disfigurement, steps shall be taken to ensure that it is not specially apparent. F. Not more than one accused or suspected person shall appear on an ID parade. So you should not have more than one accused or suspected persons appearing in one identification parade. The accused or suspected person shall be allowed to take any position he or she chooses, and shall be allowed to change his or her position after each identifying witness has left, if he or she so desires. H. Care shall be exercised that witnesses do not communicate with each other. I. Where the witness desires to see the accused or suspected person walk, hear him or her speak, see him or her with hat on or off, this shall be done, but in this event the whole parade shall be asked to do likewise. J. The conducting officer shall ensure that the witness indicates the person identified without the possibility of error by touching. K. At the termination of the parade or during the parade, the officer conducting it shall ask the accused or suspected person if he or she is satisfied that the parade is being or has been conducted in a fair manner and make a note in writing of his or her reply thereto in Form P-156. When explaining the procedure to a witness, the officer conducting the parade shall tell him or her that he or she shall see a group of people which may or may not include the person responsible, and the witness shall not be told to pick out somebody or be influenced in any way whatsoever. M. A careful note shall be made after each witness leaves the parade to record whether he or she identified the accused or suspected person and in what manner. A record shall be made by the officer conducting the parade of any comment made by the accused or suspected person during the parade, particularly comments made when the accused or suspected person is identified. Then O. The parade shall be conducted with utmost fairness, otherwise the value of the ID parade as evidence shall be nullified. And lastly, no police officer shall be used as witnesses in an ID parade unless a police officer is the accused or suspected person. The right of the accused person to privacy shall be respected at all times during the ID parade. An ID parade shall not be conducted in public unless in exceptional and unavoidable circumstances, and the suspect or accused person shall be informed of the decision to conduct the ID in public and be offered the opportunity to elect whether or not to participate in the ID parade. Where a witness identifies one or more persons on the ID parade, the person identified shall be removed and confronted with the witnesses, who shall be asked to confirm the identification by clearly indicating that he or she is the person confirmed. Then at times we can have identification by means of photographs, where it is necessary to establish the identity of a suspect or accused person through photographs. The witness shall be shown at least 8 photographs of different persons of the same race as the accused or suspected person, and the photographs shall be of the same size and type, thereby excluding any possibility of the accused or suspected person's photograph being a distinct type. The accused or suspected person shall go through a physical ID as set out in paragraph 7.5 and 6 to corroborate the photographic identification conducted under H1. Okay, so if you have been identified under a photographic identification parade, you will be required to go through a physical ID parade to corroborate the photographic identification. Where a number of witnesses are invited to view photographs, immediately a photographic identification has been made, the photographic identification shall cease, and those witnesses who have not seen the photographs shall be precluded from doing so, and the accused or suspected person shall be put on an ID parade in the usual way for the purpose of identification by all the witnesses. So some key takeaways that we can borrow from the National Police Service Standing Orders. Person to Chapter 42 is that the ID should be conducted in a fair and transparent manner. An accused person or suspect cannot be compelled to do an ID parade. Okay. The police officer should not take a witness direct to an accused or suspected person for the purpose of identification, except when they are sure that the accused or suspect is well known to him or her. The officer conducting the parade should not be the IO. What is the procedure to be followed during the parade? The accused person has the right to a friend or a counselor being present or a legal representative. The IO should not conduct the parade although he or she may be present. So an examiner can say that the IO was present but another officer conducted the parade. A student can rush to say that that ID parade is wrong. You will have failed because the IO can be present. The witness or witnesses shall not see the accused before the parade. So if the examiner tells you that the witness and witnesses saw the accused before the parade, that is wrong. The number of the people involved in this ID parade is at least 8 persons, similar age, height, and general appearance. If there is any disfigurement, like the Joey case, everyone had a bandage and a wound. Not more than one accused or suspected persons shall appear on an ID parade. So it is one person, one accused person after another. Remember that the accused shall be allowed to take any position he chooses, and he is allowed to change after each identifying witness has left the parade. Care should be exercised in that witnesses do not communicate with each other. Wakili? Yes? Hideout. So we were breaking down the National Police Service standing orders step by step, analyzing the same and not cramming. If there is any chance that a witness has seen the accused person or heard him, or that he removed his hat and then wore back, the whole parade shall be asked to do likewise. The conducting officer shall ensure that the witness indicates the person identified without the possibility of error by touching. So you should touch him. Then the accused will be asked whether or not he is satisfied with how the parade has been conducted, and his response should be written. Okay. Yes. Yes. Okay. Ungenishtua. Umesema daily ungenishtua ba. So we were still analyzing the National Police Service standing orders. So remember that no police officer shall be used as a witness in an ID parade unless the officer is the accused or suspected person. And that you should respect the privacy of the accused person. So that is what amounts to ID parades. Let us look at week number 8 on contents of the police prosecution file. Then we look at the contents of the advocate's file. At the time of recording this video, I was also sipping on coffee. so that you appreciate. The page that my notes do not have contents, but I can say it summarily that we have exhibits in the same file, witness statements, digital evidence, an inventory, expert reports, remember there is a separate video that we did on the contents of a police and prosecution file. I highly recommend that you also have a look at the video because it was well detailed. For that part I'll skip because we must have an actual file preparation component of it, because I want us to jump to week 10, 11, 12 and 13 where we have the complaint and charge, a situation that usually confuses students, and in fact in the April 2026 paper, question 1 was about joinder of persons and joinder of counts, together with the drafting element of a charge. So you must understand the various rules of drafting. Criminal litigation. Okay, let me see what I have here. So basically, if you read the method and rules of framing of charges, this is a potential area, and the same should not miss out in any examination, because charges in Kenya must be framed to 1. Disclose a known offense, cite the correct provision, and give sufficient particulars on who, what, when, where, and how to enable plea and defense, because defects in a charge sheet are fatal where they prejudice the accused or the particulars don't support the statement of offenses. A charge is sufficient if it contains a statement of the specific offense plus necessary particulars. This is pursuant to section 134 of the Criminal Procedure Code. Another key takeaway is that if you read section 135, it says that multiple counts can be joined if founded on same facts or series. Each offense must be in a separate count. Charges and informations are framed per the Criminal Procedure Code drafting rules, pursuant to section 137 of the Criminal Procedure Code. So if you allow me, we will read in verbatim the various rules that exist for the framing of charges and informations. Section 137 of the CPC. The following provisions shall apply to all charges and information, and notwithstanding any rule of law or practice, a charge or information shall, subject to this code, not be open to objection in respect of its form or contents if it is framed in accordance with this code. 1. Mode in which offences are to be charged. Account of a charge or information shall commence with the statement of the offence charged, also called the statement of offence. Then Roman 2. The statement of offence shall describe the offence shortly in ordinary language, avoiding as far as possible the use of technical terms and without necessarily stating all the essential elements of the offence, and if the offence charged is one created by enactment, shall contain a reference to the section of the enactment creating the offence. 3. After the statement of the offence, particulars of the offence shall be set out in ordinary language, in which the use of technical terms should not be necessary. Where a charge or information contains more than one count, the counts shall be numbered consecutively. Okay. Then you have description of persons, description of property, description of document, and general rule as to description. We have statement of intent. We have mode of charging previous convictions. We have use of figures and abbreviations. We have gross sum may be specified in certain cases of stealing. Then of particular importance is how you frame statement of intent. It shall not be necessary in stating an intent to defraud, deceive or injure, to state an intent to defraud, deceive or injure a particular person, where the enactment creating the offence does not make an intent to defraud, deceive or injure a particular person an essential ingredient of the offence. So this is where the examiner will be taking note that you have entered into the examination room with a penal code. Do you know how to exactly use the penal code to extract out various elements that constitute an offense? So those are the marking schemes that the examiner will be inclined to look at. Then if you read section 135 of the CPC, it continues to tell us that joinder of counts in a charge or information. Any offenses, whether felonies or misdemeanors, may be charged together in the same charge or information if the offenses charged are founded on the same facts or form or are part of a series of offenses of the same or a similar character. Where more than one offense is charged in a charge or information, a description of each offense so charged shall be set out in a separate paragraph of the charge or information called a count. Where before trial or at any stage of a trial, the court is of the opinion that the person accused may be embarrassed in his defense by reason of being charged with more than one offense in the same charge or information, or that for any other reason it is desirable to direct that the person be tried separately for any one of the offenses charged in a charge. The court may order a separate trial of any count or counts of that charge. So if the court is of the opinion that the accused may be embarrassed in his defense, the court can order that there be a separate trial for the counts of that charge, pursuant to section 135. Okay. Now, There are some key takeaways that you have to understand when you have been told by the examiner to draft. Do you know the statement of the offense? Offense contrary to this section as read with section Y of the Act. What are the particulars that the examiner will be expecting from your drafting exercise? He'll be expecting the accused full names, the owner's name or the victim's name, the date and time window, the place, the actus reus, this is the prohibited act, the property or thing. You describe the property in details. If it is a phone, you give its serial number where relevant and the value that phone is. Then you give the mental element. This is why we say with intent to defraud, without lawful authority. Then another key takeaway is that one offense per count. Don't bundle two distinct acts in one count. Okay. Number 0. Yes? Yes? Nasemaje mkile? Anakwenda sasa hapa. Kazi utaangalia. Angalia. Na tuna WhatsApp kwa tutakutumia kwa lakini kesho hapo kesho. Okay. True. Sharon, mwili yako inakataa. Kuna lazima. Sema nakuja kwa. Nakuja roho kesho ananigojea. Hiyo lazima nipitie. Lazima nipitie. Ofisi yake ni nasi kwa leo. Boys. So up to that point, I believe we have tackled on rules of framing charges. Let us look at the various defects that can exist when you are drafting a charge. Okay. We have duplicity and lack of ingredients in a charge. So a charge is fatally defective if one count alleges more than one offense, because this will result to duplicity or the charge will be duplex. Number two, a charge will be fatally defective when the count omits an essential ingredient, so the accused is not reasonably informed of the offense, and such defects are only saved if no failure of justice will be shown. If you read section 134 of the Criminal Procedure Code, sufficiency of a charge, it said that it must state the specific offense plus particulars necessary to give reasonable information. Then the rule on one offense per count emanates from section 135(2) of the Criminal Procedure Code, where more than one offense is charged. Each must be in a separate count to avoid duplicity. Then section 382 of the Criminal Procedure Code talks on credibility on appeal or revision. An error or omission in a charge won't upset a conviction unless it occasioned a failure of justice. Duplicity, or two offenses in one count, is fatal because it's unclear what exactly the accused must answer and what conviction rests on. There are some decisions that have spoken on this issue, like the case of Shikuku versus Republic 2010, where the court found that the charge sheet was fatally defective for duplicity, as it charged burglary and stealing in the alternative in one count, contrary to section 135(2) of the CPC. This defect was not merely formal but was very substantial, as it prejudiced the appellant by failing to inform him precisely of the offense for which he was convicted and sentenced. Okay. Then another duplicity was seen in the case of Samuel Mutinda versus Republic, where the High Court found that the charge in count 1 was fatally defective for duplicity, as it combined two distinct offenses of receiving and retaining under section 322 of the Penal Code in a single count, and this contravened the rule against duplicity as is created in section 135(2) of the Criminal Procedure Code. The defect was therefore substantial. Then, if you draft a charge with lack of ingredients and particulars, we can see in the case of Daniel Morara Mosea versus Republic, the Court of Appeal held that the omission of essential ingredients in the particulars of the offense of the charge for robbery with violence under section 296(2) of the Penal Code constituted a fundamental defect. The appellant, and represented at trial, was not adequately informed of the nature of the charge, which could have embarrassed his defense and resulted in a possible failure of justice. Such a defect is not curable under section 382 of the Criminal Procedure Code because the particulars did not disclose an offense known to law under section 296(2), and consequently the conviction was quashed, the sentence was set aside, and the appellant ordered to be released unless otherwise unlawfully held. Okay. So whenever you encounter a duplicity situation, this way you'll be having one count alleging two distinct offenses. For instance, you can cite burglary and stealing, that will be duplex. Receiving and retaining, duplex. Okay. One count covers multiple complainants or transactions in a way that creates more than one offense. That is still duplicity. How do you fix it? Split into separate counts as provided under section 135(2) of the CPC, or use a main count plus an alternative count, but not both offenses packed into one count. That is what the examiner will be looking at. Lack of ingredients. This is where the count cites the section, but the particulars do not plead an ingredient required by that section. E.g., where there is required intent, absence of lawful authority, violence, weapon, use of threats, ownership or possession were relevant. 2. The particulars are so vague, the date and place and act and thing, that the accused can't tell what case to meet pursuant to CPC section 134. How do you fix it? Rewrite the particulars to track various ingredients. Who is the actor? What is the date and time range? At what place did the offense happen? What is the prohibited act? Who was the victim? What was the thing? What is the required mental element of that situation? So we have borrowed various key elements when it comes to duplicity and lack of knowledge or particulars. Okay. So the other point that I also wanted us to discuss was on capital charges. How do you draft capital charges? Question 1, April paper. Mandatory question. Capital charges. Okay. What are the various rules emanating from the same? We have 10 minutes so that we can jump to the next course outline. Capital charges attract death penalty offenses or lifetime imprisonment and must be framed with strict ingredient and particular alignments and procedural. Are tried on an information in the High Court. Any formal defect must be raised immediately on plea and the court can amend or quash the information. Murder information is adequate if it clearly states the offense and gives reasonable particulars. So that one appeared to be straightforward. It is general practice rule that where you have been charged with a life-threatening offense or the one that attracts a death penalty, then you have a misjoinder, the prosecutor or the DPP is to take the charge of murder or the capital offense and then leave out the misdemeanor element so that you may not be embarrassed when defending for the most serious offense. Natoka kujiona. Nilikuwa nimemaliza vitu. Noma. Nabakisha dakika 10. Na mimi? Sasa mwamini nitukampewa na translate. Nilijiekelea tu kwa hizi. Ile plan, sasa ile na njia ya kujiona. Ndio kwa hiyo comfort learning. Ni vitu ni mingi. Ni 5 hours, tumelala 5 hours. Kwani? Hivi? Wacha nikwambie. Nje, outside writing. Kwani wana? Nice. Lazima. Nataka nijembo. Bas. Now, Thank you for your indulgence. I was at the point that we were discussing about alternative charges. I'd say that we have just a few minutes so that we wrap up our discussion, then we jump over to another course outline. So we'll do this thing until we arrive at our orals. And yeah, because if you look at the current pace that we are doing this thing, is that we are approaching an issue, then delving deeper into it so that we exhaust the required standard, including the drafting element of the same. So remember, we are breaking out with an oral session, then we come back to the next course outline until we meet the required thresholds. So allow me to finish up with alternative charges. Then I'll project various notes and books when it comes to joinder of persons and joinder of counts, because that is a critical part that usually confuses students when you're joining an adult who has committed an offense together with an adult. Where do you join counts and at the same time avoid duplicity of charges? Okay, when is the court allowed to amend a charge? When is an amendment not allowed? Okay, then how do you do an application to dismiss or to quash count? Because an examiner can also tell you to take appropriate measures and draft the necessary application. So basically, when it comes to alternative charges, you should note that these are permissible in Kenya, but only where the alternative count is a fallback on the same facts, because the court may convict on the alternative charge only if the main count fails, and you cannot be convicted and sentenced for both. Okay? Even without an alternative count, a court may convict for a lesser included minor offense disclosed by proved particulars. This is pursuant to section 179 of the CPC. Okay. Then, how do you draft? Let's say you are drafting an offense of stealing, and you have also been told to draft an offense of handling stolen property. Remember, we said that if you draft one count known as stealing and handling stolen property, you will have failed automatically because that will be duplex. That will be a duplex charge sheet. Because the main count emanating from this situation is stealing, contrary to certain provision of the penal code, because the examiner expects you to go into the exam room with a penal code. Then the examiner also expects you to look at the particulars forming the offense of stealing, because you have seen lack of particularity when it comes to particulars and ingredients of that offense. That is a bad charge sheet. Then I'm also expecting you to now draft handling stolen property as an alternative charge sheet. Okay, because the elements that form handling stolen property is that there is dishonesty where you received or retained same items, knowing or having reason to believe it to be stolen. That is the language that the examiner will expect to see on the particulars, because you have the penal code. So never make the mistake of writing count 2 and forgetting to add the alternative element part of it in brackets, so that the examiner sees that you appreciate that if count 1 fails, then with count 2 being the alternative charge, you can secure a conviction if you are the prosecutor. So those are the nitty-gritties when it comes to alternative charges. So we'll have a look at a problem question where we are required to draft, and I'll make sure that all the components displayed before you are well captured. We'll have a problem situation where we have capital charge, alternative charge, conspiracy, attempts, joint of person, joint of counts, amendment of charges in one problem question. So that is the activity that we will resume our next discussion with. Then we analyze a detailed part of the same. Then we go to plea and plea bargaining. We look at the nature of plea and plea bargains in details. So up to this point, I'll end the recording on criminal litigation, cause outline session 1, so that we jump to oral sessions. For oral sessions, if any of the participants is willing to be cross-examined on the questions that I'm going to pose before you, I'll greatly appreciate. But if you are not in a position because of the timeline, maybe you are tired, I still can proceed with the various question and answers that usually become frequent in these examinations. So allow me to end the recording for criminal litigation. Then we do orals. Then we go to what we call commercial, and not commercial, conveyancing them commercial, because the same have detailed contents. Because for civil litigation, I promise that we will analyze the civil procedure code from where we had left the same. So allow me to end, and then I resume with the oral, so don't leave